Hi, my name is Jeff Fowler, the Vice President of the Apartment Owners Association, and we're good to have you with us today. And this video is specifically for the City of LA Rent Relief Program. So if you're looking for the whole state or a specific area like San Diego or Mountain View or another area within California, next week we plan to have several videos as well that address different areas. But today it's just just the City of LA that we're going to be talking about. And so we're going to show a video, and so we're going to watch this together, and then at the end we're going to have a North Oak come and share with us, and Joel Rodstein with North Oak share with us, and he'll answer questions for us because there's a lot of confusion. And so this will just get us all on the same page to watch this and then ask questions together. So watch the video, hold the questions to the end, and we'll take some time to answer those questions. So we'll go ahead and get started. And once we finish up here, we'll have Joel on and he'll answer questions. Thanks.
Great. Well, thank you everybody for joining us. Today's presentation is done by the Los Angeles Housing and Community Investment Department. We are the City of LA's department that is in charge of enforcing various rules, primarily in the section I work in. It's the rules related to the Rent Stabilization Ordinance, or what is commonly known as the rent control laws. In addition to our typical work during the COVID period, during the local emergency period, there have also been some new rules that have been implemented, some new temporary protections that have been implemented, both at the city level and at the state level. So today we will be discussing the city rules, the state rules, and also a brief discussion on the upcoming Renters Assistance Program. There is a lot of interest in the City of LA, and I will briefly touch on that topic to provide everybody in this room that information. So first, I would like to ensure that everybody in this group is aware that today's presentation is specifically about properties located in the City of Los Angeles. It does not include any other city in the county or in the state, and it is not about the rules that are in place for properties located only in the county of LA, but not in the City of LA. Now, LA is pretty spread out. As you can see on the slide on your screen, we have a very small picture here indicating a red area, which is the City of LA, versus the county of LA. County is obviously a lot bigger, and the city is just a portion of the county. So you want to ensure that you are aware if you are located, or if your property is located in the City of Los Angeles, so that you have a better understanding if all of these rules apply to the property you live in as a tenant or the property you owned as a landlord. The easiest way to know that is by looking at your utility bill. Do you pay your water and power bill to the Los Angeles Department of Water and Power? If the answer is yes, then you are located in the City of Los Angeles. If you pay your bill to any other power company, Edison, or some other city's company, then you are not located in the City of Los Angeles. Once you have determined if the property is in the City of LA, the next thing that is important for both owners and tenants to know is whether or not the property is subject to the laws of the Rent Stabilization Ordinance, or short for RSO. The RSO has been in place since 1978 and covers some properties in the City of Los Angeles by providing regulation of rent increases, regulation of evictions, allowing only for just cause evictions, and for evictions that are not the tenant's fault, requiring relocation payment. Generally, a property in the city of LA will be subject to the RSO if it was issued a certificate of occupancy or a final permit prior to October 1st of 1978. Now, if you do not know if the property is subject to the RSO, you can text the letters RSO to the telephone number 855-880-7368. By texting the letters RSO to that telephone number, you will receive a series of questions that will allow you to identify whether or not your unit that you live in or that you own is subject to the RSO. So on the topic of the temporary eviction protections in the city of Los Angeles, I want to point out that regardless of whether or not the property is or is not covered by the RSO, the temporary eviction protections do apply to all residential units located in the city of LA. The screen you see right now shows you a list of the protections that are in place for tenants. Protection number 1 involves a tenant who is unable to pay rent due to a COVID-19 related financial hardship. These protections were put in place under the local emergency period of the city of LA, which started on March 4th of 2020 and are ongoing with no set end date. Nobody knows when the local emergency period will end, so it's ongoing. So these eviction protections apply until the local emergency period ends. If a tenant is unable to pay their rent during the local emergency period, then a landlord may not evict the tenant if the reason for the non-payment is related to COVID-19. So for example, if a tenant has lost their job, their work hours have been reduced due to closures, medical expenses due to COVID, even childcare expenses that have been triggered by the closure of the schools. If the tenant is not able to pay the rent during the local emergency period, the tenant will have 12 months after the emergency period ends to pay back the rent that becomes due during the emergency period. The 12 months cannot be later than August 31st of 2022 per state law. Tenants are not required to provide supporting documentation to prove that they have been financially impacted by COVID. So for example, if a tenant has been affected by getting reduced hours at work, they may likely have a letter from their employer, but they are not required to provide that to the landlord. However, we strongly encourage tenants to ensure that they keep a copy of all their supporting documentation should you need it in the future. Additionally, tenants are not required to sign a repayment agreement. All tenants in the city of LA who have been impacted financially by COVID-19 are protected from eviction during the emergency period and have 12 months to pay back the owed rent. If an agreement has already been signed between the parties, it is recommended that the parties seek legal advice to identify how that agreement impacts the tenancy protections. Landlords may not charge an interest rate or a late fee on unpaid rent that becomes due during the local emergency period if the tenant has been impacted by COVID-19. The second protection involves no-fault evictions. For example, Typically, under the RSO, a landlord would be permitted to evict a tenant for the purpose of owner occupancy or for the purpose of withdrawing the unit from the rental market under the ALICE Act. However, during the local emergency period, this type of eviction is on hold, and evictions that are based on the ALICE Act will have to wait until 60 days after the local emergency period ends. The third eviction protection in the city of LA is that landlords cannot evict tenants due to the presence of an unauthorized occupant, unauthorized pet, or a nuisance that is caused by COVID-19. An example of a COVID-19 related nuisance would be if there is an increase in the noise level in a unit due to children being at home due to the school closures. Now, earlier in the presentation, I pointed out that it's important for parties to be aware if the unit is regulated by the RSO or not. The main reason to understand whether or not it is an RSO unit is because there is a protection or a rent increase freeze only on RSO units. So for properties that are subject to the RSO regulations, a landlord may not increase the rent during the local emergency period and for 1 year after the local emergency period ends. Units that are not subject to the RSO are not regulated by the city's rent increase freeze. So to put it in a summary, the screen or the slide that you see in front of you gives you a breakdown of what landlords are allowed to do and what landlords are not allowed to do. So landlords cannot charge an interest rate or late fee on unpaid rent, and they cannot increase the rent for 1 year after the local emergency period ends for RSO units. However, landlords are allowed to collect an RSO and a SCEP surcharge at any time, so long as they give proper written notice to the tenant and so long as the landlord has paid the fees to the housing department. Owners can also collect a just and reasonable rent increase at any time if it has been approved by the housing department and if the owner provides proper written notice to the tenant. Lastly, a landlord can collect approved surcharges such as a seismic retrofit surcharge, a capital improvement surcharge. However, it must first be approved by the housing department, and the landlord has to wait 60 days after the end of the local emergency period. And that's the difference here. A regular rent increase, the landlord must wait 1 year. A seismic surcharge, a capital improvement surcharge, a landlord must only wait 60 days until the end of the emergency period. On this slide, you will see an image of a COVID-19 renter protections fact sheet. This fact sheet is found on our website, and it is a document that is required by the city law to be provided to all tenants. At any time the owner will serve an eviction notice. This document gives the tenants a summary of their rights under city law. And the second page of this document is a form that the tenant may fill out to notify the owners that they have been impacted by COVID-19. I would like to point out that even though the form is provided for tenants to complete and submit to the landlord, under the city law, tenants are not required to issue written notification to the landlord of their COVID-19 impact. Verbal notification would be sufficient. However, we suggest that tenants provide written information, written notice to their landlords as a way to document that they have informed the owner of the situation. So that is the summary of the current city law protections that are in place during the local emergency period. Now, separately from the city are the state law protections. And the state law protections do not replace the city law. They do not cancel the city laws on the eviction protections. The state law provides additional benefits to tenants. The state law protections were extended to June 30th of 2021 by Senate Bill 91. So the state law breaks up the protections that they offer tenants into two general categories. The first category is the time period between March 1st of 2020 through August 31st of 2020. During these months, a tenant who cannot pay their rent because they have been impacted financially by COVID-19 cannot be evicted for non-payment of rent for those months, so long as the tenant does one thing, and that is to give a declaration of COVID-19 related financial distress to the owner. This declaration must be given by tenants to landlords no later than 15 days after the tenant receives a notice of non-payment of rent. The landlord is required to include a blank copy of this declaration attached to the 15th notice to pay rent or quit. Now, since in the city of LA, a landlord cannot evict a tenant for non-payment of rent when they have been notified that the tenant was financially impacted by COVID-19, there may be the majority of situations may be that the owner does not give a 15-day notice to pay rent or quit. If that's the case, then the tenant should give the declaration of financial distress to the landlord and be proactive about notifying the landlord. The requirement to give this declaration is under state law and is required if the tenant wishes to benefit from the state law protections. This protection during the time period of March 1st, 2020 through August 31st of 2020 is a permanent protection. The tenant can never be evicted for non-payment of rent for those months if the tenant gives the declaration to the landlord. The second category of protections under state law is for the time period between September 1st of 2020 through June 30th of 2021. During this time period, if a tenant cannot pay their rent as a result of being financially impacted by COVID-19, the tenant must do two things if they wish to obtain permanent eviction protections under state law. The two things the tenant must do are, number one, give a declaration of COVID-19 related financial distress to the landlord, either proactively when the owner does not serve an eviction notice, or no later than 15 days after receiving a notice of non-payment of rent. If the tenant does give a declaration of their financial distress to the landlord, but still receives a notice of non-payment of rent, tenant should be sure to once again give the declaration to the landlord within 15 days of receiving the notice of non-payment of rent. The second thing a tenant must do to obtain permanent eviction protection is pay 25% of the rent that became due from September 1st, 2020 through June 30th, 2021. This 25% can be paid in installments, so weekly, monthly, every 2 months, or it could be paid all in full at the end of June 30th, 2021. A tenant a tenant is allowed to pay the full amount, the full 25% of all the months from September through June, so long as it's not later than June 30th of 2021. I would like to clarify an important difference between the city protections and the state protections. The state law requires that a tenant pay 25% during the months of September through June of 2021. And if a tenant does this, it will give the tenant permanent protection from eviction for non-payment of rent. However, the city law does not require that the tenant pay 25% of the rent for any of the months during the local emergency period. However, if the tenant cannot pay the 25%, then they only obtain temporary eviction protections, meaning that at the end of the 12-month repayment period, if the tenant has not paid the full amount, a landlord would be able to pursue all of their legal remedies, which may include eviction. Whereas under the state law, if the tenant pays the 25% of the rent, a landlord can never pursue an eviction in court for non-payment of rent for the months of September 1st, 2020 through June 30th of 2021. The 12-month period, the 12-month repayment period under the city is limited by state law to be no later than August 31st of 2022. And towards the end of the presentation, I will give some specific examples to help everybody understand the rule and see how it works. Now, under state law, there are several different types of notices and declarations in various languages that are available for the public. I would recommend that both tenants and landlords visit the state website, which is housingiskey.com. Once again, for those who are on their cell phones, that website is housingiskey.com. When you visit that website, you will see a folder for tenants, a folder for landlords, along with forms and information available to both parties. I wanted to share an example of the declaration under state law that a tenant would have to fill out and give to the landlord. This is also the form that a landlord would have to provide to the tenant attached to any notice of non-payment of rent. This form is available in various languages on the state website. The second page of the form will provide instructions to a tenant as to how to serve this notice, this declaration, to the landlord. The state law has some additional terms that owners and tenants should be aware of. First of all, similar to city law, a landlord cannot charge a tenant late fees. So that is consistent both at the state and the city levels. Secondly, under state law, a landlord cannot increase fees or charge a new fee for a housing service that was previously provided for free. So for example, if parking was given to the tenant as part of their rental agreement at no additional cost, the landlord cannot now remove that parking space and charge a fee in order to return that parking space. For those parties who already had an additional service fee in place prior to the emergency period, A landlord can continue to collect that additional fee, but cannot increase it. And then the third point is, if a landlord is required to temporarily reduce or remove a housing service for the purpose of complying with a public health order, then the state law says that is not a violation of the rental agreement. And it is also not considered a reduction of housing services under the RSL. An example of this could be earlier last year, a lot of landlords had to close their common area pools. That type of situation would not have resulted in a housing reduction under the RSO and would not have been considered a violation of the rental agreement either. Even though both state and city laws give tenants either temporary or permanent eviction protections if they have been impacted by COVID-19, the tenants do, however, have to eventually pay back the rent that they owe the landlords. That could be in the form of a small claims or some other type of civil action, but under state law, it can never be an eviction action. And under city law, it cannot be an eviction action until after the end of the 12-month repayment period if the tenant did not pay the 25%. So before I go into specific scenarios and common questions, I wanted to provide the group some general information on the City of LA's Renters Assistance Program. This is the program that will provide financial assistance to tenants and landlords for the purpose of ensuring that rent or some amount of rent is paid. On your screen, you will see our website, which is hcidla.lacity.org. If you go on that website, you will see a message or you will see an update on our current assistance program. If you want updates, you could always go to that website, or you could also sign up for our newsletter to receive notifications via email. The program will open to the general public on March 30th. So in about a little less than 2 weeks, the program will be open for tenants to sign up and for landlords to sign up their tenants. Both the owners and the tenants can visit our website on March 30th and complete an application to initiate the process. The general eligibility requirements for a tenant to be eligible for the financial assistance are, number one, that they live in the city of Los Angeles. The tenant must live in the city of Los Angeles. Number two, that the tenant qualifies for unemployment benefits or has experienced a reduction in their income as a result of COVID-19. So for example, a loss of their job, medical expenses due to COVID-19 would qualify a tenant. And a tenant must also demonstrate that they would be at risk of experiencing homelessness or housing instability, which could be demonstrated by a copy of a notice of eviction or a notice of past due rent, or if the unit is considered to be unsafe or unhealthy for living conditions. One or the other is required, not both. And the fourth requirement is that the tenant's household income be at or below 50% of the area median. And our website has a chart that you will see that gives you the breakdown of the exact dollar amount per household size that would qualify for the 50%. One last note is that applicants will not be asked about their citizenship or asked to show any proof of citizenship in order to qualify for the program. If a tenant is selected, then there will be two possible options for the landlord. The first option is that the city will pay 80% of the tenant's past due rent for the period beginning April 1st of 2020 through March 31st of 2021. But the city will only pay the 80% if the landlord agrees to waive the remainder of the 20%. So if a tenant owes $1,000 in rent, the city will pay $800, but the owner must agree to never claim the remaining $200. So essentially, they give up the right to recover the $200. However, the landlord has a choice. If the landlord does not wish to waive the 20%, then a landlord could agree to receive 25% of the total rent that the tenant owes for the months of April 2020 through March 2021. Under the 25% rule, the landlord does not waive their option to recover the remaining balance of the rent that is owed. Please note that these rules are in alignment with the Senate Bill 91. So now I wanted to go over some common questions and answers that we have seen from the public that are probably many of the same questions that the group has. The first item or common question that comes up is people want us to explain the city's 12-month repayment period a little bit further. And so if you recall, the general rule under the city law is that a tenant will have 12 months after the end of the local emergency period to pay back the rent that is owed that became due during the emergency period. The emergency period started on March 4th of 2020 and is ongoing through today with no known end date. Furthermore, if you recall, even though the city gives a 12-month period of repayment, the state law has placed a limit as to how long that 12-month period can be. And it cannot be later than August 31st of 2022. And so to better understand the possible scenarios, I have two examples on your screen. Example number one assumes that the local emergency period in the city of LA ends on June 30th of 2021. If it were to end on that date, then starting the next day, July 1st of 2021, a tenant would have to start paying the full rent that becomes due the month of July, the month of August, September, and so on for the rest of the year. However, the months during the local emergency period that the tenant was not able to pay or not able to pay in full, that period is protected under the city law if the tenant informs the owner that they were impacted by COVID-19. And under the city law, the tenant will have 12 months to pay that rent. The 12 months in example number one would be June 30th of 2022. So in example number one, a tenant does not get until August 31st of 2022 to pay. A tenant would only get until June 30th of 2022 to pay back the owed rent. Example number 2 is a little bit different. Example number 2 assumes that the city's local emergency period ends on September 30th of 2021. In example 2, that would mean that on the next day, October 1st of 2021, the tenant would have to start paying the full rent that became due starting October forward. So if the lease agreement says rent must be paid on the first of the month, then October 1st, 2021, the tenant would have to pay the full rent, regardless of whether or not they were impacted by COVID. However, the months during the local emergency period, which under example number 2 would have been March 2020 through September 30th, 2021, those months are still protected, and the tenant would have 12 months to pay back that rent. However, if you recall, the state law says the repayment period cannot be more than 12 months. I'm sorry, cannot be later than August 31st of 2022. And actually that should be a 30th. So under the state law, even though the emergency period ends in September of 2021, the tenant would not have until September of 2022. The tenant would only have until August of 2022 to pay back the rent. So it would not be 12 months, it would be 11 months. Now, a few other common questions. Some of these are more landlord specific. Oftentimes owners want to know if they can enter the units of the tenants for either showing the units or even for making repairs. So that can be a changing answer depending on where the city is at with the Safer LA order. The Safer LA order is constantly being updated, and you can find the most recent version of that order on the mayor's website, on the mayor's COVID-19 orders website. And I do have the link on your screen, and it's a little bit long, but it's lamayor.org/COVID-19 orders. At that website, you will find a list of all of the city orders. The first one is the Safer LA. That order specifically discusses the restrictions for businesses, including in the context of real estate. And we'll discuss what type of measures a landlord must take before entering a unit, a tenant's unit, assuming they can even enter the tenant's unit. Landlords oftentimes want to know, how do they recover the unpaid rent? So the general rule, the general answer would be that owners must be sure to follow both the city and state law notification requirements whenever they issue a notice to pay rent to a tenant. And if a tenant informs the owner that they have been impacted by COVID-19, then under city law, the owner has to wait 12 months after the local emergency period ends to try to recover the rent that is owed in any kind of legal action. We strongly recommend that landlords seek legal advice when initiating any type of action to recover rent due, to ensure that you're in compliance with both the city laws and the state laws. Another common question is, what if the owner does not want to accept the rent payment or does not want to apply 25% of the rent payments to the protected months? So we suggest that both tenants and landlords carefully document all rent payments that are issued by the tenant. So keep copies of money orders, copies of canceled checks, copies of any notices or declarations that are provided from the tenant to the landlord or from the landlord to the tenant, to ensure that you're documenting the exact actions of each party. And tenants should be sure to try to identify as best as possible what months they're paying for and what amounts they're paying. I do want to point out that the housing department does have an investigation section where tenants could file a complaint and would have a housing investigator assigned to them. That city staff would reach out to the landlord and try to reach a resolution. Parties at all times, of course, can seek legal advice. This question I discussed earlier, and that is, what if a tenant and landlord sign a repayment agreement already that is different from the city and state protections? The agreement would have to be reviewed by an attorney so that both parties can understand how that agreement specifically impacts the tenant protections. Next question would be, what forms do landlords have to give to tenants? So you have to keep in mind that you have both the city law and the state law. Landlords have to follow both. Under the city law, you have the COVID-19 sheet, COVID-19 protection sheet. It's one page, if you recall. And then the second page is the form for the tenant to fill out. Landlords must always give that when issuing an eviction notice to a tenant. Separately, a landlord must also give the state law notifications of tenant rights. And the state forms are found at housingiskey.com. The city forms are found at hcidla.lacity.org. So please visit both websites to be sure that you download the appropriate forms. Likewise, tenants may have forms that they have to give to landlords. And so the next question, I think really is for tenants, is what forms do tenants have to give to the landlord, and how do tenants serve these forms? So, of course, best practices is always to work closely with a legal organization. But the forms under state law, again, are found at housingiskey.com. And that specific form the tenant must give to the landlord is the declaration of COVID-19 financial distress. Now, if anybody in this group has additional questions or a specific scenario that they need assistance with, we do have a system by which you can submit your questions at any time of the day. There is a website link on your page, hcidla.lacity.org/ask-hcidla. So it's a long link, I realize that. But if you Google HCIDLA, Ask HCIDLA, you will find a link to a form that you can fill out to submit a question to our department. So again, just Google Ask HCIDLA and you should find our form. You could also call our general hotline, which is area code 866-557-7368. And at that hotline, tenants could also file a complaint, or tenants could also file a complaint online. Now, the complaints, as I mentioned earlier, they are investigated, but we do our best to work with all parties to reach a resolution. So we want owners to know the rules. We want owners to comply. So we make sure to inform owners of that. And lastly, there is a web page that gives you a summary of all the renter protections. And you could go to our
for tuning in, and we have had all those questions. I see there's a bunch of questions already, and we wanted to just watch this together. And then we have Joel Rodstein with us, and he's going to answer these questions for you. And why is he qualified? He is since he's been in diapers, he's been in the apartment industry basically, and for the last 15 years he's been an executive at North Oak Property Management. They have over 2,000 units, and so that they're under their management. And so anyway, he's highly qualified, and enough degrees for a thermometer for you probably. And anyway, so I just wanted to introduce him to you, and I'll go ahead and we'll just start asking those questions. And what we'll do is after this is over, we'll have those websites and things in the bottom of the YouTube in the information place there so that you can access those easily. And anyway, so let's go ahead and get started. We have lots of questions, and we'll just go for it. So thank you, Joel, for being with us today. And the first question here is from Jebster. And the question is, will there be a limit on the amount of back rent that this will cover?
As of now, it's only a time period. So anything from March till March is the time period that they're talking about. So again, if you go in with this system, you will apply for 80%, you will give up 20% of what is owed, and that should be it. It does require the tenant to cooperate, and there's not too many rules out yet on what happens if they don't, and can you force them. But I don't know many tenants that won't cooperate with the owners to get this done, because it's free money to them. And you as the landlords are giving up a lot of money. It's not something to be taken lightly.
Great. And Andrew on YouTube here, what if the tenant doesn't cooperate? And what if they don't qualify based on AMI?
If they don't cooperate or they don't qualify based on their income, it's very possible and likely as of now that this will be they'll have a year to pay you back. And that's just what it'll be. So from March to August, you'll have to use that like consumer debt where you actually sue the tenant. And then from September through March, you would actually have to, through June. So again, September through June right now, you would actually have to give them a year to pay you back. In County of LA, they do have to pay the 25%, which should have shocked you guys all. That county, they do have to pay the 25%. But for the city, if they don't pay you the 25% that's state mandated, there's no consequence to them. So it all depends on county, city, if they qualify. Which is why this YouTube that was put on today is really good for you guys to keep and reference back to, because it's very hard to keep track of.
Yeah, unbelievable that this could be happening, right? I think we're all still just in shock that this is even happening. And here we go. This is from Ralph on YouTube. What if property has not been registered with rent control yet?
I'm not quite sure why it wouldn't be registered. Maybe it's not under rent control. So it would still be under LA City if that's what you're speaking about. And you would have to follow the city rules, and you would have to apply to the city's website through HCID, rather than on through the county, if you will, the state, where the Housing is Key website. So it all depends on where your property is. Is it LA City or another county or another city? And the best way to figure that out, the easiest way, is obviously to look at utility bills, things of that sort, which will tell you. For LA City, you'd have a LA DWP bill. For county, you might have some other utility bill. And then when you go to the website, Housing is Key, you'll actually choose what county your property's in, and then you'll follow down the questionnaire there. And that's the best way to go about that.
Right, and the speaker was from the Rent Division of the City of Los Angeles Housing and Community Investment Department. That's a mouthful. The Rent Division of the City of Los Angeles Housing and Community Investment Department. And she did give a number that you can call to see if you are subject to the RSO, and it was 855-880-7368. That's 855-880-7368. 7368. And that's another way. So look at your utility bill. If you can't figure it out, give them a call. Thank you, Joel. I'm excited. I love having Joel on because he always knows what he's talking about, and it's great. Okay, so Batul, if someone removes the property from the market with the Ellis Act, can they sell it right away?
If the Ellis Act has already, if you've done the paperwork, if you've gone through everything and you've qualified, you have to wait the 2 years, which is part of that, then I wouldn't see why not. But without seeing the case, without seeing the documentation and dates, you should be very careful of when you pull it back from the market and how long you wait. It's 2 years. So, and there is paperwork to file as well. So really the one that will be able to help you out with that is your broker who's going to help you sell it. And that's the way I go about that.
Great. And so what we normally do, we do these things live, and you come in and we all line up along the side of the room and we just take one question at a time. So you may notice that I skip over your question, and what I'm trying to do is just get at least everybody, get everyone's question answered at least once. So please don't be frustrated if you think I'm ignoring you. And I'll move on to the next one here on Pavel on YouTube. Tenant refuses to pay the bills. Water bill is already $1,500. What can we do as landlords?
Unfortunately, right now, a landlord can't do much, which is the very frustrating part of this whole ordeal. I think that you should constantly be explaining to them that they do need to pay, that the money is not waived. For the people who have buildings in LA County, again, not city, but LA County jurisdiction, and the other jurisdictions that you can apply now, I would tell you guys to apply now. Tell your tenants you've applied. Tell them this is their opportunity for their back rent to be forgiven if it's approved, and that they need to cooperate with you. If you put it in a text, in a sum, in a thought that will show them it benefits them when they may or may not be hurting, they're more than likely to help you. So I would definitely tell everyone to contact your tenants, tell them about this relief program. And again, there's some of you who have very little balance with some tenants. That's different. You need to treat that differently as well. But again, there's nothing you can do, unfortunately, to make sure that they're paying, especially in LA City. In the county, again, if by June 30th they haven't paid the 25%, you could start the eviction. LA City, again, there's nothing you can do, unfortunately. So call your tenants, find out what's going on with them, try to get a sense of what they can do. Obviously, everybody just got stimulus checks. You could ask and be careful, because there is tenant protection rights in place for harassment. And I would advise you guys to ask. You can ask, but document the calls and be very careful of what you say. Because in this time, if you guys noticed, some of the last slides from the city talked about tenant protection. It didn't say anything about the landlord protection, right? But it said tenant protection. So and it said to document if the landlord doesn't want to take your payment. So everything that you guys do in regards to this situation, I would highly recommend that you document it. I spoke to the tenant on this day and asked them what's going on in their world. How is it going? Could they, pay the 25%? What were their plans in the future? And document the call. And it might seem very cumbersome, which it is. And all of this has been put on your shoulders as landlords, which isn't fair. You guys have the water bill, as you just mentioned, to pay. You have property taxes are coming up. There's a lot of bills that you have to pay, and no one's giving you for free for a year. So I'm very conscious of that, and that's why I'm telling you to protect yourself the best you can.
Right. They call it the Tenant Relief Act, and I know Dennis Block, he calls it the Tenant Welfare Act. And it is really frustrating, and there may be nothing that we can do with the tenants for the most part, but what you can do is you can write a letter to the governor, and with the recall effort that is happening right now, I think he's a little more willing to listen to people. So if you write a letter, not just an email, but write it out and send it to him, that'll really help. The AOA magazine also has a letter from one of the members in there. You could even just tear that thing out if you have the magazine and highlight the stuff that you really want the governor to read, and write another little note on there and send it off if you'd like to. And but yeah, this is, it's, yeah, I'll stop there. Here we go. Facebook, Alex. So these rules for LA City doesn't necessarily apply to other cities in California. Am I right?
You are correct. And that's why best thing to do is when you go to the Housing is Key website, and then it will direct you to your county or your city's page for this rent relief. If it's done through a city, it'll direct you right to there. If it's done through another county, it should go through. But going on your county's website, city's website, usually you can find each and every one. We have buildings, from all the way from Alhambra down to Torrance, and all the way to Ventura. So we deal with many different cities, and what I spend most of my days doing in the morning and at night is checking those websites to see if anything magically popped up. Cities like to wait till the end of the month, and counties for that matter, to do anything so that you don't have a chance to correctly plan. So they'll wait till a Friday night to post something. So it's our world has changed. It's no longer that you can just wait for the wonderful AOA magazine to fill you in. You have to not only read that, but you also have to be online and check the city and county's websites daily.
Right. So do that. Check those daily. If you're not sure what it says, call in to AOA if you're a member, and you can ask one of the advisors, "Hey, am I reading this right?" Just to make sure. Am I getting the right information here? And also next week we'll have a couple more live streams that are more specific. I know one for San Diego we're going to have, and we're working on one for Northern California. So we're just going to continue to try to get information to you and direct you to the right resources here. And here we are, Jonathan on YouTube. Tenants' habitability plans are not easily maintained due to COVID-19. Is there any leeway for that?
Currently, with those, there is not any leeway, and getting permits or finishing that work or having tenants postpone your work is all a reality. So again, you want to be you want to be in contact with your contractors and the tenants more so than you ever would. In the past, we would all serve the THP, the tenant habitability plan, and it would say what's going to happen, and that would be the end of it. We wouldn't really let tenants get in the way. Right now, with COVID and people quarantining, you have to be mindful. So more communication is key. I believe most inspectors are somewhat understanding of this. More of them are willing to take photographs so that when you can get into a unit or do that inspection for the seismic retrofit or something to that effect, you can get things signed off with a picture. I've been more successful than ever with that. So again, documentation is key. Talking to your tenants, letting them know what's going on, and then usually they'll bring it up rather than the day of the inspection, you're there to do it, and the tenant says, "Oh, you can't come even near me because I have COVID," and it ruins the whole thing. So communication, again, is the only thing that's
all right.
gonna
On
help you.
Facebook, we have Janet. For capital improvement rent increases, can I issue 30-day increase notice on the 30th day after the moratorium or the 60th day?
It depends on county or city. Again, you got to refer back to the slide in there. But I believe it was they're going to hold you off for a year in LA City after it's done, regardless of when the work was done, which is another atrocity. But I believe it to be 60 days after the year, because there are no increases for 1 year in LA City. After the moratorium is ended, and again, it hasn't yet, so you got to keep that in mind as well.
All right, Jay on YouTube. Since the moratorium is up 6/30/2021, why is the rent assistance only from April 2020 through the end of March 2021?
It's a great question. There's many many dates, many things that just don't add up that make me feel like there will be a second round of help. There will be a pushback in the moratorium all the way till, past June. If everybody noticed in all those slides, it kept talking about August. Now, whenever I've seen a date in the past when we've been into this, magically that date is extended. So we're going to have to wait and see. That's the real answer, because nothing's firm. Nothing's been called off. So it could be extended.
Yeah. And on YouTube, Tien, she's just asking, she's owed 35,000, but what if their tenant is not qualified for the program? And I think you answered that. Just have to take them to small claims court. Is that right?
For the protected period, yes. So from last year till August, again, that's like consumer debt. If they don't qualify, you're going to have to sue them once this thing is over. And for the period from September forward, they have a year to pay you back. So it's horrible. They owe you that much, and to hear that they don't qualify for this program, what I would stress to them is that they do owe the money. And I stress that to them. You should have already served them many notices by now that the state and the cities have required. But you need to stress to them that you're not going to waive any of this, that you are going to pursue whatever you can, and you want to make a plan for them to pay you back. Because anything that you can do to get that money back is better than leaving it up in the air for what the judges will do. The judges will not be kind, I believe, to many landlords. They're going to feel sorry for the tenants who lost their job or whatever else, and not care that you have mortgages, property tax, utilities to pay. So I can't stress enough that, again, communication is key. And if all else fails, I would tell you to go to the tenant and make some sort of deal where they leave and give you back possession for you giving up some portion. And again, that's a drop dead. They don't qualify for this. The second round comes out, and again, they don't qualify. That's something that you're going to have to consider. And I know it's a very emotional thing. This is your livelihoods. But I ask that you treat it like a business and make business decisions with cool, level heads, because it is very easy to be frustrated with this situation. I know on a nightly basis, I sit at my desk and worry about my clients and ask if I've done everything I can, and which tenants are telling the truth and which are not, which show up with a brand new Lexus when they say they don't have money for the rent. I have it all, as you guys can imagine. So, but again, I have to remove the emotion and go, you need to make business decisions.
Great, thank you. And on YouTube, Sir Mac, do these rules apply to Section 8 tenants too?
They do apply to Section 8 tenants. Hopefully you've been getting your portion from the city or the county for their portion, but obviously the other portion that's left over, the tenant does need to pay, and they do fall under this. So you guys need to keep very good ledgers showing what the tenant's portion is. You need to keep in contact with the tenant's rep from Section 8 to explain to them the situation, at least drop them an email saying, hey, they haven't paid their portion. Because at the end of the day, most of Section 8 tenants, most of them should be able to afford their portion. And by so, they don't want to lose their voucher, because if you were to evict them for non-payment, they would lose their voucher. So you should be successful as long as, again, you keep the communication going. You don't, it can't be combative, but you need to keep it going and explain to them you're not going to waive it if they don't qualify, which in this case for Section 8, most tenants would. But communication, again, I'm going to go back to that, and also stress that for Section 8, get their advisor involved. Let them know what's going on so that they can also explain to the tenant their rights, but as well that they do need to pay the rent.
Great. And Maria on YouTube here. Do I have to serve past due rent notices every month, even if they're paying 25%?
At this point, you do not. There's many different opinions on this. Obviously, I'd ask you to speak to your attorney who handles your evictions, because ultimately they're going to be the ones who have to go through with the case if you are going to start an action. but it is my policy that I have not. We've served the notices that we're required to. All my tenants have access to their ledgers online at any given time as well, so they know their balances. But there's been, I believe it's 3 or 4 notices that they've had to receive by now. So they know, and no, I would not serve that notice. It could be construed as harassment in my mind. You giving a conversation with them, asking them what's going on, that they do owe the rent is a much better plan to me at this point in time. And again, everything is changing, which is why I made that comment earlier that you guys need to be on top of the city websites, AOA's website, their email. That all needs to be part of your daily ritual, unfortunately.
Great, thanks for the plug there. And so you basically, you've served it through the tenant portal for your purposes?
When the notices were required, we did, we put it in their portals as well as gave them a paper copy. On this most recent one, to ensure that they received it, we actually stuck it in the mail as well, which is one of the options for this past one that was due, I believe, back in February. So.
Okay. And if you don't have property management software, AOA is developing some, and we have some spots for beta testers. If you want to get connected with that, call in to AOA and just ask for me, and we can connect you to that. And right, thank you, Maria, for that question. And off to Melanie. We've already received 3 ERASP payments, but does not state that we have to waive our rights. But it doesn't state that we have to waive our rights to the payments. That's a question. So she's already received some payments of some sort from ERASP.
I believe that Melanie is speaking about the $2,000 that was LA City sent out. Considering that the county just opened up not too long ago and LA City hasn't yet, I believe that's what she's speaking about. In that agreement for LA City, at least, there was some stipulations as to when you can start an eviction, which really didn't matter because the newest things overlapped with that. So it's not going to affect you one way or the other. And then so far in the county ones that we've applied for, there were no stipulations either. The state rules still apply for the county. Again, LA City isn't open. It's not open till the 30th of this month at 8 a.m. So have all your paperwork ready. It's very important that you're ready and that your tenant knows that they're going to be getting an email or paperwork from the city. So that's what I would prep for right now.
All right. Thank you, Melanie, for your question there. Kirsten on YouTube. If a tenant does not pay full rent on July 1st, 2021, can you evict them?
It depends again. It depends again if they are LA City, LA County, another county. Has the pandemic been claimed to have stopped? There's many questions still not answered. As it stands now, some places yes, some places no. So again, you'd have to refer to what city and county you fall under and their rules, because as of now, it's, to be quite honest with you, county, yes, July 1st, they didn't pay. You would serve a 3-day like normal and then proceed. For city, it hasn't been stopped, the pandemic and the moratorium. So I don't know what the mayor will do, unfortunately.
Okay, here's Cali fan of California. Maybe not so much right now with these rules and regulations, right? But I have an RSO building in LA. Can I post notice for the 3% increase legally? Or when can I legally post that increase?
60 days after a year, after a year, you can post the notice. But again, that's going to probably change in my opinion. But as of now, it's after a year from when they say it's over. And again, right now they haven't. So we have to wait. They will, I'm sure they're going to redo something to extend it, to solidify it, and then we have to wait again. But right now, per the documents that you guys watched, it's a year after.
And if you remember at the end of the presentation too, like they had the common questions, and they dealt with 2 different scenarios of if it ended here, what would it look like? You could also refer back to that to get more information. All right. Thank you, Cali fan. And Zipporah, how can I, on YouTube, how can you sell your multifamily property with the unpaid tenant still in the unit?
Many of my clients, and I've gotten some new clients who have purchased buildings during this time, and the debt is dealt with two different ways. One is that the buyer assumes the debt, so that if they got anything back, they would get it. Others have kept it, hey, everything from before, when I owned the building's mine, and when you purchased it, it's yours. So there's many different ways that can all be negotiated out through escrow and when you get an offer. But my concern is obviously with these programs that we're trying to recover from the state, how the money will be treated. So it's my opinion, if you're selling the building and you can have the buyer assume the debt, that would be what's best at this point in time, because they're going to be filing these applications. For example, if you sold it today, somebody bought it in LA City, they can't apply till the 30th anyways, and they would apply. And then you could show proof that the debt was assigned to the buyer. So that's one way. But again, it can be done any way. It's up for negotiation. My only concern is how you will collect on that. If you, as the person who sold the building, can you file an application to collect the past due rent, the 88%?
Right. And we have this 30-day window coming up here where we apply. With programs like this, what do you think we can expect? Like, how long do you think it would actually take for them to actually get a check in hand?
As of now, I have no clue.
Right.
I wish I did. I wish they'd tell us. It has to do with your tenant cooperating, them getting all the paperwork. There's so many unanswered questions, which again is very frustrating for everyone. So I honestly don't know. We put in all our applications the second that it was opened. I believe it was a Wednesday night. And we're waiting just like everybody in LA City and other cities who are doing it themselves. You're not going to know until they open it. Yep. Not much has been leaked to tell us about these things.
All right, here's one from Andrew on YouTube. Are there any qualifications on the landlord that would restrict their ability to participate?
As of now, there are no restrictions that I know about that would restrict you from collecting the past due rents. There's nothing to my knowledge.
Just they have to waive that 20%?
Correct. So they'd waive the 20%. And then obviously everyone, if the tenant applies and you don't want to for whatever reason, you would still get that 25%. But I don't know of anything that would preclude you from collecting what you're due.
Okay, here, Joanne on Facebook. Doesn't Section 8 pay a bigger portion of the rent if the tenant loses income?
That is correct, and usually it's done on an annual or semi-annual basis. So that's why I would have you guys reach out to your rep for that tenant from Section 8 and explain your case. Hey, they haven't paid the rent. They're supposed to. What's going on with them, and see if they can make exceptions. See if they can pay more. Because you're right. If their income goes down, Section 8 is supposed to pay more. But again, it's done annually or semi-annually in the past. So, and not to mention they're very slow. I have some clients who want to take Section 8 payments, or we have to now. So we've been taking them, and it takes months and months for money to come through. So yes, the answer to your question again is, if their income goes down, isn't Section 8 supposed to pay more? The answer is yes, and that's why you should reach out to your Section 8 rep.
Okay, Batol, good to have you with us today. If I applied for the Ellis Act before, does that mean 60 days have to wait to execute it, or after 60 days I can just give notice?
Can you state the question one more time? I apologize.
If I applied for Ellis before, does that mean 60 days that they have to wait 60 days to execute it, or after 60 days you can just give notice?
Without seeing the paperwork, I don't want to comment. Especially now, it's very specific, and I'm sure you're going to get a lot of pushback. So this would be one for probably a real estate attorney with the Ellis Act. And that's how I'd proceed with it, because there are so many things changing and put on hold, and you need to dot your I's and cross your T's on this one.
All right. Well, getting close to the end here. Pavel has a question again. Is it tenant's responsibility to provide landlord with the form?
No. When a tenant can apply now, like an LA City tenant or other cities can apply now on their own, and then you would actually get an email or a form from the city or county and state for that relief. But I would be proactive. Again, if a tenant's not going to do anything that's not easy or for free, right? So I would be proactive. I would not wait for the tenants. I would apply. I would tell them now. My LA City tenants are getting notices this week telling them, hey, here's what's coming. We want you to get your paperwork in order so that we can help you out and help ourselves at the same time. It's in both of our best interests to do this. So I would not wait for a tenant. I would not depend on a tenant to do it, because at the end of the day, you're the one who puts the food on the table for yourself, and they don't care if you have anything to eat, unfortunately.
Great. And Tian on YouTube, tenant filed Chapter 7 bankruptcy. Do we need to oppose rent debt discharge in bankruptcy court since the rent debt is protected by laws, like a student loan?
I believe that you will have to get a lawyer involved and contend it, but the question is when, because technically it's not due right now, right? Only 25% is due from September through June. So the question is when when does this all end? When is the money actually due? And then you can move forward. If they filed the BK and it's talking about rent from the protected period back from April through August, then yeah, you're more than likely it's probably gone, because it's consumer debt, which is again why I would say go to them with the rent relief, make a business decision, and see if you can't get some of that anyways.
Okay, here's QD on YouTube. City of LA emergency orders allows tenants to add extra occupants without needing approval. When emergency orders expire, will property owners have any right to remove unapproved extra occupants?
The extra occupants is a very tricky subject, because as in LA City, for example, we all know that you have 60 days to say that they're an additional occupant and say they have to leave or charge us 10%. But as we all know, you can't do either right now. So what we've been doing is we've been sending a letter to the tenant saying we don't approve this additional occupant, but we understand for the time being that they can self-quarantine together, or they can quarantine together or live together because of COVID. And we tell them our intentions once COVID ends. So that's how I would treat that. And with animals as well. Your question dealt with extra occupants, but it has to do with dogs, cats, other pets. So I would do the same thing for them and say, hey, we don't approve this animal. We understand that it's your right under the city or county, state moratoriums. And as such, you can keep them for the balance of this, but it is our intention that your lease says you cannot. And that way you've documented your intentions. You've documented that you did know about the animal or person in the required time. And that hopefully will help you afterwards. Again, we don't know. That's the horrible thing about this whole thing.
All right, Amy on YouTube. The mother of my tenant, which is doing well financially, signed the lease as a guarantor. Can I ask her to pay the rent that's owed?
Yes, you can ask a guarantor for any past due balance. I would encourage it to say, hey, this person who you guarantee the lease for has not paid their rent. I do not anticipate, foregoing any unpaid rent. Are you willing to come into a payment plan with me? So yes, we have contacted the guarantors of the tenants.
Great. And Pavel, again, what do you do if the Section 8 itself is not compliant? Like they can't get the social worker is unreachable and there's no one, they can't get a hold of anybody. How do you have an in there or a way that you get around that?
My suggestion is that the squeaky wheel always gets the grease. So you need to email, you need to call different numbers, ask for supervisors, and obviously we all need to understand we're not all sitting in an office now. We're all maybe working from home or anything else. So within reason, they should be getting back to you. But if they're not, you do need to ask for supervisors. You do need to contact whoever will listen to you and send emails as well. I know that we've sent emails to Section 8. For example, today we won't get a response for 2 weeks, but we've, emailed 2 or 3 times again in that span so that we have it documented that we're doing everything we can to communicate.
I like that. Document it like that. Make it documented. And then Andrew again, would Joel be willing to share the proactive notice he's giving to his tenants? But
that's part of my services, and so if anyone's interested in my services and as a client, then I'd be more than happy to. Otherwise, I'm going to keep that in-house, but I will share it with the AOA and see if they're interested in creating their own, because it's very important that you guys support the AOA and that they obviously have the tools to help you.
Right, and check the AOA website too, AOAUSA.com. You can check the COVID area. I think it's on the left side of the page there. And Joel, man, if you want him to manage your property, North Oak, they manage thousands of units already, and they're ready to take care of you, and they have a good system in place. So definitely look him up. He's been really helpful and just such a friend and kind of like someone that we can walk side by side with, and so we're just glad that we could have him on the show. Any parting words, Joel?
No, I just want to thank everybody for their time, and also just tell everybody to keep in it and don't get emotional about this as emotional as it is. Do business decisions, and I wish you all the best. Stay safe.
So we're going to have Dan Fowler, the president and the founder of AOA, come up, and I heard a story just recently, and these things are really depressing and really tough, and I just thought I'd share the story. But there's a story of 2 frogs going into a cup that is full of cream, and one of them saying, "Oh, we're going to die," and the other one is said, "Just hold on," and as he paddles and paddles and paddles, he ends up making butter, and he makes it. And so just want to encourage you to just keep fighting and keep enduring. I guess that's a better word. Keep enduring all of this, and let's we're going to get through it to the other side here. But I'm going to turn it over to Dan Fowler now.
I want to thank you for coming in on the AOA streamers today. I'm sure earlier this morning I had a seminar, and then again with all this good information that was given, up-to-date information and practical hands-on information. And we're happy that you were able to sit in. I have 2 things to cover with you and then 2 requests to make. Number 1, I was reading an article the other day, and there's a lawsuit against 88 different property owners, housing providers, and property management companies. And what they had done, they've called, there's apartment for rent as one example. The apartment was for rent, I think it was 1950 or 1970. The gal called and they talked to her and told her about the unit, and she told her about her qualifications, and everything looked real good. And then they were about to hang up, and she says, "Oh, one more thing. Do you take Section 8? And they, "Oh, no, we don't take Section 8. We don't have those types of renters in our apartment." Well, she had been recording the conversation, and it was one of 88 housing providers, property management companies that had answered that question that way. And they were filing a lawsuit against all of it. Can you imagine the millions of dollars of damage that they're going to get from that group? Those attorneys are really going to make out when they take their share of all that money. So I just want to remind you, it's discrimination if you turn down your Section 8 for the reason that they're a Section 8, or that you advertise or tell people that you have a policy of not accepting Section 8. So you want to be sure that you don't get caught doing that, so you don't get caught being recorded telling people that you do not rent. Number 2, suggestion, bring up those of you who may be buying a single-family resident as a rental or buying an apartment building. It happened the other day that the people bought their new home. They were ready to move in. Escrow had closed. The seller had received all of his money, and they went the next day to move in, and he was still there. None of his furniture had been moved out. He says, "No, I'm staying here. You can't evict me." And so he was staying in his house. Got all of his money. Now he was going to live rent-free for the next probably 12 months. At least he would get it just because of his friendly politician who stopped evictions and will not allow it, and didn't make an exception such as this. Of course, you can't expect the politicians to know that there should be exceptions like this. They've never provided housing. They've probably never run a business in their life. Many of them have never worked in their life. They've always been employed by the government, and that's the only employer they've ever had. So you can't expect that kind of thing from them. And this is a couple reminders. Be sure that if you're closing an escrow, get an inspection the day of the closing or the day before to make sure that everything's cleaned out, to make sure that you have the keys. In this particular case, the owner went over to mow the lawn because the old owner was letting it go now. Went over there to water the lawn, bought a hose and hooked it up. The owner came out and cut the hose up. Said, "Get off the property." Can you imagine that? You're the owner of the property, and this guy's telling you, who's freeloading and living rent-free and have cheated you in this way, telling you to get off your own property. So be sure to have that inspection whenever you close escrow. 2 requests that I'd like to make today before we wrap this up. Number 1, I'm going to ask you to write the governor a letter. Dan, you asked me last week. I wrote a letter. Write another one. Write a letter. Many of you that are listening have never done anything whatsoever to help stop all this unfairness and all this cheating of property owners out of their property rights. You've never done anything to stop it. Join together with the rest of the housing providers. Write a letter to the government. Say, "Dan, I don't know what to write in a letter." Well, then take the AOA magazine from this month. There's a great article in there. Tear the article out, put it in an envelope, and send it to the governor. You'll never have a better time. You got a recall going on right now. He's going to pay more attention to voters right now than any other time in his career. So write your letter now. On the outside of the envelope, write "Stop Forced Labor and Free Rent." Write it on the envelope. The mailman will see it. Anybody else who's handling that will see it. The governor will see it, even if he doesn't open the letter. And the people handling it in his office will see it. Stop forced. Like you say, "What do you mean, Dan? This forced labor?" They don't. There's no forced labor. Oh, my friend, if the lawn needs mowing, an apartment owner has to go over and mow it. If there's a leak in a faucet, you have to fix it. If you need a new water heater, you have to order one and install it. Say, "Oh, Dan, I have other people that do that." That's labor if other people are doing it. And if you're supervising it, the last I heard, supervisors get paid for doing that, and that's considered labor. And you're providing labor for your property. The politicians are forcing you to provide free labor. Now, that doesn't sound too good, and it reminds me of laws of years and years ago that forced people to do forced labor like this. And it's pathetic. It's pathetic that the politicians would allow such a thing. Demand that they stop this inequity of free labor, forced free labor, and free rent. So you want to write your letter and send it in. I'm going to put up on the screen the address to send it to. And we're going to leave it there for a minute so that you can get it all written down. And write your letter if you have a personal example. Now you say, "Dan, I don't have any vacancies. I'm collecting all my rent. Everything is going just fine." Well, that's really nice for you. How about the other people in your industry? Join in to protect them. You know, they get the other guy first, and then someday they come after you. And your turn will be there. So let's try to stop it now before it gets to you. So get that address down. Write the I was going to say mayor. Write your mayor too. Write the mayor of your city and let him know what you think about this, how unjust it is and how unfair it is to do this to you. Many of them think that you just buy your apartment, you buy the apartment, and you collect rents, and in 30 years it's all paid for. And that's the extent of the knowledge that the people who are passing these laws and proposing these laws that they put on you. And they also in your letter, you might say the solution to this problem would be for the state to issue vouchers. Ask for vouchers in your letter. The vouchers will solve the problem. And not vouchers just for low-income tenants. Vouchers for any rent that you've been foregone as a result of these eviction laws, as a result of closing the courts up so that you can't evict somebody. Even the rich, there are rich people not paying their rent out there. Dan, I don't have anybody. Other people do. Write your letter for them, because again, they're going to get to you eventually. So you want to get a voucher, say, oh, the politicians tell us we're all in this together. You have to donate your property. Well, if we're all in this together, then send some vouchers and let the state participate in this freebie stuff, in this forced labor, and also in this free rent. You participate too if we're all, I don't believe we are in this together. They're against housing providers, and that's the way it's been going, and that's the way it is right now. So you want to write this. Also, number 2, that's request number 1. Write your letter, make your arguments there, and get it in writing. Send it to the governor now. No better time. There is no better time than now. So get it done, please. I beg you to get it in. Number 2, make a donation to the AOA Political Action Committee. We'll get it up there on the screen, the address that you can send it to. You can also send it to that address. Leave that address there for a while. And also you can send it to the, if you want to go on to the website, it's the AOA Political Action Committee, PAC, aousa.com/PAC. And you can send it in on the internet if you'd like to send it in with your credit card. You can also make donations in this way. We're building an AOA industry war chest. We need to build up the funds so that when they put another proposition on the ballot, we'll be ready for them and we can hit fast and strike right away, as we should be able to do. Also, we would like to take a major case to the Supreme Court or join in with another organization to have a lawsuit to the Supreme Court. It takes a lot of money to do that, and we need you to back us up. How much did you send? Send in $100 a unit or $1,000. You have 20 units, it'd be $2,000. If you have 20 units, you can afford to. Oh, I can't afford to do that, Dan. I can't afford that much money. Well, you're going to lose more than that, and you've lost more than that if you've owned a building for any period of time in the past. So send your donations in. Support the AOA war chest. Let's build it up so that we're ready for these crooks and can go after them the next time they come after us. I think a lawsuit's probably going to be the only way that we would eventually do it. The Supreme Court has 3 new people there that have replaced 3 people that believe in redistributing your wealth. The new ones basically don't believe in redistributing your wealth. So now's a good time to try to get up to the Supreme Court and carry a case all the way. I want to thank you for dialing in today and for watching the AOA stream. Again, I hope you discovered at least one idea, and I'm sure you did, that'll help you make it or keep more money than ever before, and or make your job of managing, providing housing easier, more profitable, and more enjoyable. Thank you for being here today.